This would be case D559019. Counsel, Parental record.
Kenneth Friedman, file number 5311 on behalf of the plaintiff, or behalf of Ms. Haverlock.
Okay.
Your Honor, I'm Gary Zarnich, my bond number 7963. I'm here on behalf of Tyler Haverlock. I'm here for the Smith Legal Group, standing in for Kurt Smith.
All right. Court has reviewed the plaintiff's underlying motion, dad's opposition, counter motion, as well as mom's reply. We'll start with, I don't know if there's anything that has occurred additionally since those filings that's relevant.
You know, Judge, I wish I would have known this. I guess my client is somewhat, and I apologize, she might be a little embarrassed. This was somewhat of an abusive relationship, and if I would have known this, I would have put this in the paperwork. I would have put this in my paperwork pursuant to our motion to change custody under Castle. That dad, and the reason I bring it up is because if you look at my exhibits, you can see that his behavior towards mom is still somewhat similar, although they don't live, and there hasn't been any violent behavior since the parties have separated.
No, that's the question, and I'll tell you that's probably what I'm sending the kids out. When did they really separate, or were they really getting along like he alleges?
Oh, no, Judge, there's really no, and I can tell you how there's no dispute. There's no dispute because Dad's work schedule, he works 6 in the morning until 2:30 in the afternoon. There's really no dispute on the schedule. He may say it's been going on for 18 months instead of 24 months. There's really no dispute. The kids have been with mom. He sees the children between 2 and 3 days for 4 hours a week for the past 2 years, and every other weekend. Week 1, he sees the kids for about 12 hours a week.
Okay, you understand that that's not what he says in his pleadings.
And I understand that, Judge.
Okay.
And I'm just going to tell you how there's really no dispute because he can't.
You can't tell me how it is. You can relay what your client's telling you to say.
Okay, I can. It certainly seems that way based on his work schedule from 6 in the morning to 2:30 in the afternoon. But
that's why I said, listen, I don't, other than contrary representations of what occurred, and again, he says that they were getting along, it got a little bit relaxed, they were actually over at his more than normal. Listen, you...
Right, I understand, yes, sir.
What? Listen, 11-year-old can absolutely relate. I don't know that the 8-year-old's going to be able to, but I think I can interview both of them and see how it's been for the last year or two.
Absolutely, Judge. What I would ask for today, with the court's permission, is there's really no dispute also on the $2,000. He owes my client, and under the statute, he owes my client $2,000 in back child supports. He acknowledges that he didn't pay it because of some BS excuse that my client agreed because of extracurricular activities. That's not true in any way, shape, or form. I attached in my reply.
Listen, I'm not going to rule on that today. I will let you and Mr. Zerdich, you're correct. If in fact that's owed and it's not disputed, it's just going to end up in a judgment, Mr. Zerdich, and then we just need to figure out how that's going to get paid back. But under Claudia and that line of cases, I'll just explain it to your client. Even if you had primary custody of the kids, or even joint, you have to come back to court to get your child support modified. In fact, the case law related to it, the father had custody of the kids for I think it was 3 years, if I recall the fact pattern. He still owed child support to the mom because he didn't go back to the court to change the order.
I understand.
So you owe what you owe. And we'll reconsider the amount when we get back, but I absolutely want to have the kids interviewed because we have divergent stories about what's occurred in the last year and a half.
And Judge, one other thing. At this point in time, at a bare minimum, we filed a motion to change custody and for a review of child support.
I'm not doing that today.
Well, I'm just asking, Judge, just based, even on joint custody, the case law specifically says a couple things didn't occur. Number one, the calculations weren't correct in their original joint petition. It was all it says was $800 a month. They didn't put in there what his income is. His income has gone up by more than 20%. We filed our paperwork, so I did my calculations just based on a review, on a child support review, because the case law, Fernandez-Rivero, is crystal clear that you have to put the proper calculations in. If you don't, and we can also establish, because the calculation was done incorrectly back then, we can't go backwards. We can't.
I know that. I just told him that.
Right, but what we want to do today, Judge, we filed our motion in
I'm not
October.
going. I will be back when I look at it all at the same time, Mr. Friedman.
But
we'll be back in 30 days. Back in 30 days.
I understand, but it is a big difference in child support. It's another $700 or $800 a month, even at a bare minimum.
Okay, let me consider what the girls have to say, and I'm not denying it, I'm just deferring it till we come back.
And Judge, I know, I just want to get one more thing, because my calculations are, I'm just saying,
That's fine.
my calculations are, he either owes $18.92 if it's primary, and if it's joint, he owes $15.98.
I will turn to the defendant and say, be prepared and save that amount of money when we come back, because it may be ordered that you pay that amount. I'm not ordering it today. And then again, Mr. Zerdich, I know you're unbundled, but at least talk to Mr. Friedman about the arrears and how that's going to get paid back.
Well, I have a short argument in that regard.
Again, we'll deal with it. We'll deal with it all when we come back.
Because I definitely don't dispute that he could modify child support without a court order, but I think that there could have been a voluntary waiver for a few months, and as soon as she said, you gotta start paying again, he started paying again.
For a few months?
We don't dispute that there was $2,000 of child support.
Hold on.
But,
An implied waiver,
no,
an express waiver. He has it in some sort of writings.
an express waiver, no, he has her telling him he'll waiver, and then going on vacation with him, but that's another thing about the custody, you know these club sports are expensive, and they travel.
You know
They
what?
spent 5 days in San Diego.
That does not.
4 days.
Show me anywhere in the child support scheme that has any sort of impact, Mrs. Ernst.
Well, it doesn't, except for the fact that if there was a waiver.
You guys
and
are going to end
relied
up
upon that
expending
waiver-
more in attorney's fees over a $2,000 amount than the If you want me to set an evidentiary hearing about some sort of that, I'm not going to determine on a motion hearing. But if
Yeah.
you're trying to argue some sort of waiver, Mr. Friedman might get attorney's fees if, in fact, you can't prove a waiver. I'm not making a determination today.
We could,
I'm not making a determination today. Not making a determination today.
regarding the custody, so we're coming back for the custody issue, so we'll just reserve our
We're,
argument. Because we have all that about.
it has,
them,
yeah,
we're
it
going on
has to
vacation
do with
them,
the underlying allegations, and you guys are the one that I'll turn to the plaintiff. Did you get 2 DUIs in the last couple of years?
No.
Do I need to look?
She had 1 DUI prior to the divorce. Correct?
Correct.
1 DUI prior to the divorce.
All right.
And also prior to the divorce, like I said before.
The query to the children are going to be de facto and about the parents' relationship for the last year and a half, and I guess currently, and then we'll determine from there whether there's
Can you-
adequate causes. That's
Well,
it.
Can you perhaps question them about their travel schedule to do too? Because they're saying they're representing that the two of them aren't getting along, but he's saying they're going on vacation together. She's staying in the room with them on 3 trips this summer, which I think is relevant to. She's saying she wants to change custody because he's like domestically violent, and you know she's just throwing that out there based
I
upon
will
a couple
ask
of
them
text
about the de
messages, which they just.
facto and their parents' relationship for the last year to year and a half. And then we'll get a report. So, 30-day return date, Madam Clerk.
December 3rd at 11.
Again, Mr. Zernich, I would strongly suggest you talk with Mr. Friedman about the arrears issue. I think what you're claiming is a little bit going to be hard to prove at the time of a trial, but
I definitely will talk to him about that. I recognize the difference.
and again, I need, just like I say, I want to be clear. I'm not denying Mr. Friedman's motion about the modification. Your client needs to be able to save the amount. He makes, again, according to, and I don't know if this is going to change your calculation, Mr. Friedman, he grosses $88.77 a month. You need to save up the amount of child support as they allege, at least for this month, because you might be owing it when we come back. Okay.
We'll return with a willful underemployment claim for her. She cuts hair for a living. She works 3 days a week without any reason why she's not working 5 days a week. Doesn't have a bank account that collects cash. I think that it's a little disingenuous that she's the income that she's claiming.
This, so that my client doesn't have health insurance because she can't afford it. Jesus.
It's, listen, she, I'll note the one thing that I noted when I went through it. She lists 800, I don't know if she even was listing
She did, she listed the 800 for his child support.
His child support, she lists nothing as income, and then she indicates in her actual reply that she earns approximately $2,500 a month.
No, Judge, if you look, it's on, she's self-employed, because she's a hairstylist. It's on page 3 of her FDF. It says, what's your average gross pre-tax monthly income? It's $3,000, then she lists her expenses of $545.
What does she put in her actual reply, Mr. Friedman?
No, that's exactly right. She makes about $2,500 a month. That's exactly what her FDF shows.
Okay. Description of parents' relationship. You want last year or two, or just the last year?
Last 2 years.
And that's it, working 3 days a week on a 6-hour shift. So she essentially works 18 hours a week and wants my client to supplement her with more child support.
You know what?
Which probably is gonna go up, but we should at least find that she's
Mr.
capable of
Zernich,
earning more money.
again, I know, are you unbundled for today, by the way? Mr.
That I'm
Zernich?
not- That I'm not sure, my client might know that.
What? Right. Is Mr. Smith unbundled, I should ask?
We are not unbundled.
Okay.
We're retained on this one.
So 30-day return date, Madam Clerk?
December 3rd at 11.
Thank you, Your Honor.
Listen, I'm just gonna throw out there, again, Mr. Zernich, I realize you're with Mr. Smith's firm. I would suggest you even crunch the numbers. You're welcome to get on. If you don't believe what she earns, then the most the court can do is use Nevada average wage for a hairdresser. It's gonna be nowhere comparable to what your client earned, which is almost $9,000 gross a month.
I know.
So my guess is even under a joint situation, he's probably gonna be at the caps.
If that would be the
Please
case,
talk
there'd be
with
no
Mr.
sense to
Friedman.
even,
Right.
even try to crunch numbers, yeah, I get it.
All right.
Thank you, Your
So again, I just want to be nothing of substance. We're just going to talk to the kids. Everything will be deferred till we come back.
Yes, sir.
All right.
Thank you.
All
Thank
right.
you.
Have a good day.